Can an at-will employee be laid off without cause? Imagine working at a company 4 years and suddenly finding yourself laid off without any warning or explanation. It might leave you wondering if that's even legal. Well, in most parts of the United States, it is. This is because of a rule called at-will employment. Under at-will employment, employers can end your job at any time, for almost any reason, or even for no reason at all. The only exception is if the reason is illegal. That means they do not need to prove poor performance or misconduct to lay you off. They just have to avoid illegal reasons like discrimination or retaliation. The idea of cause is important here. Cause means a real job-related reason, like violating company rules or not meeting performance standards. But in at-will jobs, employers are not required to have cause. They can decide to lay off employees simply because they need to cut costs, restructure, or change their business plans. This is different from jobs that requiring just cause, where the employer must show a valid reason for termination. There are some important exceptions. Employers cannot fire someone because of their race, gender, age, disability, religion, or other protected traits. It is also illegal to fire someone for reporting discrimination or safety issues. If there is a written employment contract or a union agreement that spells out how layoffs happen, those rules must be followed. When it comes to layoffs and reductions in force, or RIFs, at-will employees can be included without needing a reason. As long as the layoff isn't based on illegal reasons like discrimination, it's generally lawful. For example, if a company is losing money or reorganizing, they can lay off employees even if those employees have been doing a good job. Most employers don't have to give a reason for layoffs in at-will states. But if an employee thinks the real reason was illegal, they might have grounds to challenge the layoff. Courts will look at things like timing, patterns, and other evidence to see if the reason given is just a cover-up for illegal conduct. This flexibility helps employers adjust their workforce as needed. For employees, it means job security can be limited unless they have a contract or are protected by law. Knowing these facts can help both sides understand their rights and responsibilities during layoffs or terminations. So, to answer the question directly, yes, an at-will employee can be laid off without cause, as long as the reason isn't illegal. This rule applies broadly, including in situations involving layoffs and RIFs, making at-will employment a common feature of the U.S. labor system.